Welcome back to Ascend Legal 101. I'm Ramona, and today I'm joined by lawyer Dana Quantz, who has been practicing at the firm of Hutchison Ozcek Marlette since 2011. Dana practices civil litigation with specialties in personal injury, insurance, labor and employment law, construction, and human rights claims. He prides himself on delivering first-class advocacy and representation to all of his clients. He regularly appears in all levels of the British Columbia court system and has appeared before the British Columbia Human Rights Tribunal, the Workers' Compensation Appeal Tribunal, the British Columbia Labour Relations Board, and the Employment Standards Branch. He is an active member of the legal community through involvement in local, provincial, and national bar associations and trial lawyer associations. Please help me welcome lawyer Dana Quantz. Thank you for joining me again, Dana. I really appreciate you coming back.
My pleasure.
So today I thought we could talk about BC employment law and about what happens or what happened in the pandemic when suddenly everybody was losing their jobs or people had to go home and their unemployment situation or their employment situation was very uncertain. And what happens what happens when you get laid off? What happens when you just lose your job or are furloughed? And I'd also like to talk to you about employment agreements and frustration of those employment agreements under common law or under the BC Employment Standards Act. So first, can you tell me I guess there's different things happen depending on your employment status or who you work for, or if you're unionized or not.
There's essentially two types of employment. There's union and non-union. You're either subject to a collective agreement or you are part of the private sector or management. So it's an on-off switch. And if you are part of a union, then your entire employment situation is dictated by the collective agreement and you are represented by the union. Well, I speak to a lot of people who aren't happy about that, but the part of getting the perks of being under the collective agreement, so getting can't be dismissed without just cause, there's access to benefits, pay step-ups, all of these sorts of things. You have some of the burdens. And I mean, for the vast majority, I think unions do a good job representing their employees. They're there during the disciplinary process. But employees need to understand that unions are their representative. So if they say they've been dismissed unfairly, or they say that the employer is not treating them properly, it's the union that needs to step in. And the union's authority comes under the collective agreement. The only thing a private outside lawyer like myself can do vis-a-vis an employee in a union is determine if the union is following its duty of fair representation, which I would say is a rather large or a low bar to get across. So it's whether they're acted arbitrarily, in bad faith, or gross negligence. So if they get above those pretty low standards, then the union's done their job according to the BC Labour Relations Board. In terms of whether you're in the private sector, if you're in the private sector, then the terms of your employment aren't set out, often in a large collective agreement, but there are people who have employment contracts, there are people who have verbal agreements, there are people who have mishmash of some things are signed, some things aren't. So it depends on the situation. And private sector and unionized, for that matter, are all subject to the Employment Standards Act in BC, which sets out the minimum standards by which any employment terms of employment need to meet.
And so in terms of what we saw happening when the pandemic first came, when people were at home or people were being laid off, if you are in the private sector what are the standards, or what standards needed to be met for you to be laid off or fired, or, you know, under the BC Employment Standards Act?
Well, I'll correct you first.
Okay.
Private, it's unionized or not unionized. Private sector and public sector are often used, but I think that's a misnomer. There can be private sector unions, like when forestry or mining or all these sorts of things. There can be public sector, so government employees who are not subject to collective agreements.
Right, right.
So, I think that's something that people often forget, but it's important. In terms of whether a layoff is allowed, essentially it's whether it's part of the industry that you're in. To boil it down, we're talking about a lot of topics today. Layoffs could be one whole topic, but it depends on the industry you're in. So if you're, say, in the oil and gas sector where there's freeze thaw, that can, or you're in fishing where there's good, bad, there's forestry. So if you're in a sector that's subject to seasonal up and down, such that layoffs are normal part of the business, then layoffs can be contemplated either by expressly laid out in either the collective agreement, the employment contract, or just by custom in the industry. Or if they're not, then layoff is simply telling someone that they're laid off is a dismissal. So if you take your standard office worker who's not accustomed to being laid off, if an employer comes to them and says, due to this pandemic, we're laying you off, that constitutes a dismissal. And that triggers all of their dismissal rights. The only thing that's allowed, however, is if the employee agrees. And I would say what happened with the pandemic is the vast majority of people, if they're being told they're being laid off, agreed. So a good chunk of people I've spoken to, both on the employee and on the employer side, most people were able to come to appropriate arrangements, and they just said, look, we can't operate, we're being shut down, or we have to shut down, so we're going to put you on layoff and we'll wait and see. And the employee's like, okay, they agree, they go off. The BC government put in certain exemptions, so allowing the time for a layoff. So previously to this, there was, I think it was 17 weeks, but I'd have to check that. Prior to a 17-week layoff would result in a dismissal. So if you came to an office worker and said, I want to lay you off temporarily, a temporary layoff is allowed under the Employment Standards Act if it's agreed or if it's part of the industry custom. And then once it gets past the certain number of weeks set out in the Employment Standards Act, then the temporary layoff becomes a dismissal. And the government allowed employers to apply for exemptions. I don't think you can anymore, but there was a period of time in which a lot of, I think, busy employer council were applying to the BC Standards Branch to get exemptions to extend the length of the temporary layoff, which would have worked probably for larger employers who have thousands of employees. That would have made a lot of sense to apply for. Whereas some smaller employers, they just decided to accept at that point that these employees were dismissed. So in terms of whether a layoff is allowed, it really depends on the industry custom or whether there's an agreement. And then layoff has a certain time frame until it becomes a dismissal. And what I mean by a dismissal is that the employer has terminated the contract, which triggers severance notice rights under whatever employment documents matter. So that being the collective agreement, Employment Standards Act, the contract, or the common law.
Right, I see. So the term that I have heard. And certainly when I was a manager, um, I received quite a lot of advice about employment contracts and whether or not they were frustrated if somebody couldn't come back to work.
Mhm.
And can you tell me about how, sort of, what's the threshold that frustration is under the act, and then I guess under common law, because sometimes it's quite different.
Well, I would say frustration actually applies similarly under the Act. I think the Employment Standards Branch, and particularly the Employment Standards Tribunal, have done good jobs in making employment law relatively consistent across across the spectrum. I mean, there's little differences between tribunals and the common law, but I think I would I mean, I can't say unequivocally, but like in terms of frustration and layoff, the Employment Standards Tribunal and branch have kind of taken their cue from the from the common law. So there may be small differences, but the large tests that we're looking at apply relatively similarly. Frustration is really a common law doctrine that applies to circumstances that are beyond anyone else's control. So beyond the two parties' control, the employer and the employee, that radically change the nature of the contract. So if the circumstances result in something that's totally different than what the two parties contemplated when they entered into the contract, and that change is looking to be permanent, but it doesn't necessarily have to be like guaranteed permanent, but it's not changing anytime soon. Then frustration can be found to void the contract, meaning that no party has any obligations under it. So the two kind of classic examples of frustration of contract in the common law is in the employment sector is fires and long-term disability. So fire, for example, you work in an office building or a factory or something and it burns down. The employer can't rebuild. There's no, like in the circumstances, if the employer is not rebuilding the factory, they're just cutting their losses and moving forward, then the contract of employment for all their employees would be viewed as frustrated because of a circumstance that was beyond anyone else's control, and it wouldn't impose further liability on the employer in that respect. That tends to happen relatively rarely. And I would say the more common case in employment law tends to be with long-term disability, where an employee is off on leave. They're in receipt of long-term disability benefits, and it usually comes up in BC Human Rights Tribunal cases, occasionally in cases before the courts, but not as often. It tends to be more of an issue before the Human Rights Tribunal on the duty to accommodate, where the employee is off on disability leave, the employer determines that they can't have this person back, they terminate her employment, and the person says, no, you failed to accommodate me. In both those instances, the obligation's on the employer to prove that due to this person's disability, which is no one's fault, like there's no fault applied here, the nature of the contract is completely different. So if you're working as a bricklayer and your injury to your back means that you can't lift anything above 5 pounds, then your ability to work as a bricklayer in this job under these job requirements may not be, we cannot accommodate. It's not to the point of impossibility, but it gets pretty close to that. The employer needs to show undue hardship in human rights jurisprudence, or pretty close to that, that the contract is radically different. So where an employer would have to accommodate this bricklayer into a payroll position because they don't have any other jobs that don't involve lifting, then they could say, look, we don't have to accommodate him to the point of a payroll position. Those are kind of your classic frustration cases. We don't really have much jurisprudence in employment law, like modern employment law, like with Bardell, starts in the 60s, and then we have employment standards legislation. The last time we've seen a pandemic like this, so being the Spanish flu, is in the early 1900s. But our employment law hasn't had to cope with something like this. And I would say the cases I'm dealing with now, where COVID is being addressed, look at whether the pandemic results in an increase in reasonable notice. And if you want me to explain that, I can. And there's one case out of Ontario that doesn't really do anything. And so there's a lot of arguments and negotiation. And I think it really is context specific. Like I'm sitting here in Victoria. Basically, since government has taken off the mandatory lockdown of everywhere, we have a crazy job market where there's tons of work everywhere, except for probably the hospitality and airlines and a few things that are clearly impacted by COVID. But generally, other places are struggling to even just hire people. Mm-hmm. So I think that impacts reasonable notice, where you may have other places where like Ontario, where the lockdowns were perhaps more severe for a longer period of time.
And is there a specific period of time, like we would say some sort of limitation period? So after 2 years, we're calling it frustrated and walk away, or is it just it's on a case-by-case basis?
It's totally case by case. If you're an employer and you have a chief operating officer of a small but lucrative company, and the chief operating officer is off for a couple months, and that's going to completely destroy the company, that's a different scenario than you have a factory worker who part of their contract includes long-term disability benefits that allows for a long-term disability for 2 years for their own occupation and 4 years, for example, of any occupation. That employer may be required to wait the 6 years total till the disability benefits run out to determine if this individual is ever going to be able to return to work. Whereas the chief operating officer, it may be impossible for the employer to operate for more than a few months. Now, that being said, it's important to emphasize that the burden of proof is on the employer. They can't just make decisions. So they have to try. If the employer wants to claim that because this chief operating officer is off, have they tried to hire a temporary person? Have they promoted from within? Can someone step in to cover the role? Have they tried hiring? What steps have they taken? If they just say, look, we can't have you be gone for this period of time where our contract is frustrated, and it's not clearly set out in the contract. And I mean, I've seen contracts that say that, and they're questionable whether they breach the human rights code. But in those instances, you still need to prove either that the contract's frustrated or that they were suffering undue hardship. So right. It's still a heavy onus on an employer to prove.
So this is just another wiggly thing. What about benefits? So if under somebody's employment, they are guaranteed whatever benefits, say they have a maybe perhaps a formal policy in place, maybe not necessarily a written contract, but there's a policy that says everybody gets this. You're on long-term disability. You keep the person on the benefits for an extended period of time because, you know, you're trying to avoid a human rights claim or something like that. at some point when you realize this person's not coming back, can you say, look, at our contract is frustrated and we need to cut you off the benefits now and have a nice day? Or, you know, what do you do? I think if somebody is still on long-term disability, or there's perhaps it's a WCB case, you know, where you know that there's an extended time off and they're not coming back.
It's so context specific.
Right.
When someone is off and they're receiving benefits, if the employer still considers them an employee, then they're entitled to access to the benefits and the benefit plan. I would not recommend to any employer to just unilaterally terminate benefits unless they're starting to really seriously consider that this person's not coming back, the employment's frustrated. I think it's always with the caveat that the employer should speak to either their corporate in-house counsel, their corporate counsel, or an employment lawyer about determining if there is grounds for frustration, because it's context specific. If the person is still receiving long-term disability benefits or they're receiving workers' compensation benefits, it really depends. I mean, workers' compensation, the WorkSafe BC has an internal mandate to try to get people back to work with the employer. So if they have a permanent condition, so that we aren't just talking about a temporary leave under the WorkSafe, but if they have a permanent condition, the person's entitled to vocational rehabilitation benefits, which goes through a pretty standard protocol. They try to get them back in the same job, the same employer. They try to get them back at the same employer with a different job, then same job, different employer, then different job, different employer. Right. So they kind of have a whole schedule they go through. So if an employer just says, well, they're off on WorkSafe benefits and I don't have to wait for them to come back, they may be faced with a human rights complaint, right, that they didn't hold the job. So, but it's context specific. It depends. There's no requirement that an employer hold their job, but they're going to have to prove undue hardship. Like if the complainant proves that there's a failure to accommodate, namely not holding their position while they're off, then the employer needs to prove undue hardship. Now, there's all sorts of deductibility issues that I won't get into. If the person's in receipt of WorkSafe benefits, there's deductions of what they can claim for wages and all sorts of things. So it can get complicated very quickly.
Right. So in this case, in the case of the pandemic, and you think you're going to go back to work, or you hope you are, is there, what mitigation is, you know, there's got to be some kind of reasonable way we can work this out, right? So how do you go about doing that?
From the employee or the employer side, because it's very different.
The employer's side. Actually, let's do both. Let's do both. I'd like to hear both.
Well, the employee has an obligation to minimize their loss. So if we're talking about someone who's not a unionized employee and they don't have a written employment contract setting out what their compensation is, then they have an obligation to mitigate. The common law implies in that situation that they're entitled to reasonable notice, absent there being just cause for dismissal, reasonable notice that the contract was ending. And so a lot of people will confuse that with severance, but it's reasonable notice. And a lot of people will claim in a wrongful dismissal that essentially employer did not give me adequate notice, my job was ending, so I'm entitled to wages in lieu of the notice I should have received. One of the employer's defenses to that is, well, If you're claiming 12 months reasonable notice, you didn't take reasonable steps to find work. And so we think you failed to mitigate your loss. And so you should only be entitled to 6 months, for example. The employee, when they lose their job, has an obligation to look for work. The court expects them to do what any reasonable person would do in the circumstance, is to go out, go onto internet boards, look for work, search for jobs, and jobs that were within their qualifications that make sense, apply for them. And if they're thinking of taking legal action, they should probably be keeping a list of jobs they've applied for, steps they've gone, interviews they've gone to, so that they can establish they've taken steps to mitigate. If they can't show all of that stuff, then the court may conclude that they have not acted reasonably because they have sat and just collected the CERB benefits or EI or things like that. It's an important defense for employers that don't often succeed, largely because I think most people do take reasonable steps to look for work, because I don't think a lot of people have an incentive to sit without any income. So people take reasonable steps. And it's an often maligned defense where employers will just say, well, you haven't done this or that, which is just nitpicking. But if there are jobs available to be applied for and the person's not out applying for them and they can't prove it, then the employee will have issues. I mean, I've gone to the point of I'll occasionally send jobs. If I'm acting for an employer, I'll send jobs to an employee. Say, well, we think these are in your qualifications. They pay about the same. You should apply.
Right.
And I'll bring that to, and I'll say, this is with prejudice. I'm bringing this to your attention now. If you can't produce applications or tell me what happened with this, then like I'm trying to create evidence for my client, but also I just hope they find work, frankly.
Right.
Because that's in everyone's interest. In terms of the pandemic, the biggest argument I'm hearing as when I act for employers from employees is that I can't go out and find work because of the pandemic. It's limited employment options. And as I said, where I'm located, most of my clients are in the greater Victoria area. Unless you're in hospitality or some of these industries that are just obviously impacted by the pandemic, that often does not bear. I mean, in the legal sector, we're smoking busy. If someone came to me saying the pandemic's limited my ability to find work, that's probably not gonna be borne out in the evidence at the end of the day. So it's really about, are there jobs available? Are they applying? Are they taking reasonable steps? Now, a person who is a chief operating officer at a company doesn't need to apply at McDonald's. There needs to be some equality in the position, whether it's in terms of pay, seniority, status. So it has to be reasonable. But yeah, the obligation's not on them to completely reinvent their life. But even if we're getting to a year and they're looking for in a very niche sort of job, they've got to expand, or a niche location, whether it's in Victoria, they've got to expand their search. I mean, they have to take reasonable steps, and what's reasonable depends on the circumstances.
Right. Well, I have to say, I think I could probably ask you about 100 questions, and I'm hoping you can come back to talk to me about different subjects, because the more you and I talk, the more questions I have. So thank you very much for coming back and for explaining all of this to me. And I'm wondering, is there something that I've missed or is there a question I haven't asked that you feel is really important that people should know?
That's an open-ended question. in terms of something that I'm sure I will regret a couple months from now when a decision is rendered. But I think something for people who aren't in the touchstone dealing with this every day, whether they're employees or employers, is trying to figure out the impact of the CERB benefits.
Right.
And I would say most people, at least the position I've been taking is that the qualifications and this comes out of the one case in Ontario, but the way the entitlements, the way the money was paid out, how it was, who's qualified, who has to pay back. I mean, it changes all the time. So there's often the question, well, this person, we laid this person off in March, we terminated them in June, and they're now claiming wrongful dismissal against me. And we know they've been on the CERB benefits until at least November. Surely we're able to deduct that. It's a mess to try to sort out. When I'm acting for employers, I'll say, yeah, sure, we can deduct it. When I'm acting for employees, we'll say, no way, you can't deduct it at all. It's a giant mess. The practical approach I've taken is that the CRA deals with that. The law, I think we talked about it last time, in Sylvester in British Columbia, is still the law regarding deductibility of benefits, in that if the employee contributes to the benefits, or if the benefits are strictly employer contributed, then that's how you determine. So if the employer strictly determines or strictly contributes to the benefits, the classic example being WorkSafe BC, where it's a completely employer funded system. Those are, if an employee is claiming wrongful dismissal or human rights lost wages during a time where they were in receipt of temporary wage loss on a WorkSafe claim, then all the temporary wage loss is deducted from any claim, because that's paid for by the employers. That's the employees can't be paid twice. Right. So similarly, if an employer is paying for the entire premium of a long-term disability plan, then an employee is receiving wages, they can't claim those wages back, even if they claim wrongful dismissal. It gets murkier when you have joint contributions. So employment insurance is a standard one, as is long-term disability, where both parties pay the premiums. Now, employment insurance often is not deducted at source. That's one of the things that Sylvester in BC talked about. Sylvester in BC was about long-term disability. Basically, with employment insurance, it's not deducted off of the damages. So what happens is, if a person receives employment insurance while they're off and they get wrongful dismissal damages, the Service Canada or the Employment Insurance Commission can come and ask them to repay those benefits. Whether that commission wants to do that or not, or they want to invoke repayment, is often on the commission's decision. Employers can be held responsible, but often releases or settlements or judgments are not if the employer pays it all out, then it's on the employee to pay. But there are certain situations where if the employer is concerned about the employee going bankrupt or spending all the money and not having any, that the employer may want to insist upon the Employment Insurance Commission kind of certifying that there's no repayment obligation here. That's kind of the main thing that I get a lot of questions about, is the impact of CERB, and frankly, no one knows. I think most employment counsel, whether on the employee or on the employer side, are just trying to sidestep it in order to get agreements done. we'll eventually get a decision where a court has to decide it, but we don't have one yet.
Right, and I guess because we're sort of in it still. I mean, we're not getting CERB, but it's changed to, I guess, an employment insurance. So this CRB, is that right? Or something, there's something like that, right? So we're still in it. So it may very well be that we're not going to see an impact till maybe quite some time down the road, would you say?
It's possible. I mean, we're starting to get cases. I'm
Mm.
I'm getting cases that are filed that will involve the issue, whether they actually, for every employment case that actually results in a decision, there's probably 90 that settled. So we need some cases will eventually show up that couldn't be resolved. We'll just see if the issue ever has to come up. That's the beauty of the common law and litigation. They deal with issues as they arise. I suppose the only other thing I would tend to caution, because we've talked about frustration, is, and I think I've said it before, is that employers need to be so careful when claiming frustration. So one of the things that if I was an employee counsel, I would be wanting to know, as the employer applied for all these wage subsidy programs, what sort of steps have they taken to bring back workforce? Like, you have to cross your T's and dot your I's if you're going to claim frustration. It's not just a quick phone call, 15-minute consult. There needs to be some decent evidence in available, particularly if there's long-term disability plans available. So.
Right.
They haven't taken a look recently as to whether the Employment Standards Branch has been dealing with some more of these decisions from the hospitality sector, because it would make more sense that those claims end up there, since they tend to be more minimum wage part-time positions where frustration is being claimed. But the hospitality sector, there's got to be some claims that are being brought forward, being dealt with by the Employment Standards Branch. Same with the airline industry. I mean, I'm sure there's some grievances that are being filed and moving forward. I'm not aware of any decisions yet that kind of lay out a decent framework to analyze it.
Right. Well, this will be something that we're going to have to keep our eye on. And then I'll have back and talk about it.
Sounds good.
I think also maybe next time, if we sort of set the intention right now, next time you come back, can we talk about things like overtime? And those are, they're not pandemic related issues, but I'd like to talk about the things that people come into my office and say, these are all the problems with my employer. And, I'm always sending them out the door to talk to their employer, to talk to somebody else. But I refer to the BC Employment Standards Act quite frequently, but I can't give legal advice. So I think I would just like to be clear. I'm hoping you can help me be clear on things like overtime and time off and things like that.
Sure.
Which I'm interested.
In the meantime, you can't give legal advice, but there are self-help guides on the Employment Standards Branch website. So if people have questions, they have interpretive guides about the Employment Standards Act. There's information available if people know where to look.
Okay, perfect. Thank you very much. And thank you again for coming back to see me, and we'll see you again soon.
Sounds good.
Thanks.